Hello and welcome to the City Newsroom. Now, about a month after Mr. James Gyakye Quayson won the Assin North seat with over 17,400 votes, a member of Assin Breku, Michael Ankoma Ninfa, on January 6 applied to the court, the High Court sitting in Cape Coast, basically calling for his status as MP to be revoked and also for him not to be sworn in as a member of Parliament. Now, the case from January 6 has travelled all the way for close to about a year and a half through the High Court sitting in Cape Coast to the Appeals Court and now to the Supreme Court. The application basically is that Mr. James Gyakye Quayson should not hold himself as member of Parliament for the people of Assin North, as he did not qualify as an MP, basically violating Article 94(2)(a) of the Constitution, which states that a person cannot hold himself as Parliament if he owes allegiance to another country other than Ghana. Now, there is a substantive case and also there is an injunction case which basically is seeking that the Supreme Court restrains him from holding himself as a member of Parliament. So the ruling regarding the injunction application brought before the Supreme Court has been given 5-2 majority. Now, in a few minutes or seconds, we should see lawyers for various sides of the case coming out, and we'll be picking their reactions as to what they make of the ruling and the implications for people in Assin North with regards to their representation in Ghana's Parliament.
For me, it's an affirmation of long-established principles by the Supreme Court. The Supreme Court had in earlier cases decided that the proper time for reckoning whether a person is qualified to contest for Parliament is the opening of nominations, the period between the opening and close of nominations. If within that time you're not qualified, you cannot be qualified at all later on. So for me, this is a sound application of a principle of law that has long been established by the Supreme Court in Yeboah against J.H. Mensah way back in 1997 to 98, and then the recent Senator Rollins, where Atuguba established clearly that it is the opening of nominations that should be the determining factor as to whether a person is qualified to stand for election or not. And I think that there ought to be even application of the law. There ought to be an equal application of the law. The same fate befell Adamu Dramani Sekande. He was not qualified at the time that nominations were opened, and we don't know what happened to him. As the High Court that had earlier on held the seat, for me, the people of Assin North will not be represented, and I think that were not for all these legal gymnastics that had been employed by the lawyers for Assin North, perhaps the by-election should have been conducted long ago. And I, in my view, think that there's even nothing in the way of the Electoral Commission to declare the seat vacant. The High Court has ruled, given a judgment determining the status of the gentleman as not qualified to have stood for election, and had actually cancelled the election conducted in the Assin North constituency. And the Court of Appeal subsequently struck out this appeal for non-compliance with the rules of the Court of Appeal. So there's no appeal pending. And I think the way is clear. But of course, the Supreme Court has ordered an expedited hearing and determination of this matter. Yes, I believe that the Supreme Court hearing definitely will also affirm all the principles of law that I have indicated had early on been established by the courts of Ghana.
As Attorney General, it must really worry you that between now and whatever time that the Supreme Court would have had the substantive matter, the people of Assin North, their right to representation would have been taken away from them.
I don't think that is any right to representation which has been imperiled at all. I mean, it must be established clearly that the Supreme Court does always exercise its powers to grant an injunction in constitutional matters. It's a court of law and equity, and therefore the main basis for determining whether an injunction ought to be granted is whether indeed a clear case of unconstitutionality has been established. And as I indicated in the argument to the court, each passing day that the gentleman continues to unlawfully go to Parliament, he breaches the Constitution. So it's a running unconstitutionality. And I think that the Supreme Court is in its right to halt such a patent and running unconstitutionality.
Your client, even in an attempt to enforce the constitution regards parliamentary elections, is also minded about the right of his own people, including he himself, to be represented in parliament. This has been the lingering concern from day one of this. How do you reckon the people of Assin North will be represented up to the time that the court would have duly dealt with the matter and fresh elections conducted?
The right of representation is not a stricture by itself. The right of representation is steeped in law. You can't have an illegible person running around as a member of parliament for a constituency when he is not. It obviously leads to a mutilation of the sovereign will of the people of Assin North. They are better off now without someone who is parading as a member of parliament whilst he is not, whilst we await the decision of this court. The mere fact that they don't have to quote a member of parliament at this time does not in any event strip them of what they are entitled to as citizens of this country. At any particular point in time, there will be a needed representation from the new patriotic party for the Assin North constituency.
Let me say that the Supreme Court has given its ruling, but we vehemently disagree with their position. I think that it is a sad day for all of us. That if what it means is that Assin North is also not going to have representation in Parliament for as long as this case lasts. That is a sad situation, because there are precedents in this country. We all remember the case in Ayawaso, West Wagon, where the lady was allowed to stay in Parliament until the final day of the determination of the case. So I thought that the Supreme Court will consider that situation and allow a representation. You see, this is a representation matter. If people have voted for a person, this is a representation matter. They deserve representation in Parliament. And so we thought that when the case is on, we could still have a representation in Parliament. But that is what the Supreme Court has said. The legal team will meet, of course, and also officially know the next step to take.
So we heard Baba Jamal, a member of the legal team of James Gyakye Quayson, speaking at the Supreme Court right after the court restrained himself from holding himself as a member of Parliament for Assin North. Now, spokesperson for the petitioner, that is Mr. Michael Ankoma Nimfa. I believe, this ruling basically, makes you happy.
For him, he came to court to seek justice. And at the end of the day, justice has been duly served. So he is happy that indeed the law has been put in its proper position. It's incumbent upon every citizen of this country to ensure that the law works. That has been the sole objective of Mr. Michael Ankoma Nimfa, that someone who seeks to pass laws for me, you, and whoever is viewing to abide by should be the first to uphold the law. He shouldn't embark on flagrant disregard for the law. And that's exactly what happened. That's exactly what James Gyakye Quayson did. That at a point in time, at a material moment that he knew that he was a Canadian citizen, he appeared before an officer of the court, that's a commission of oath, and lied on oath that indeed he did not owe allegiance to any other country apart from Ghana, at a time that he knew that he owed allegiance to Canada.
My colleague Sixtus Dongolo was in court, and he would bring some more light on what transpired, the implications and other matters.
Michael Ankoma Nimfa came to the Supreme Court with two applications that the Supreme Court should interpret Article 94(2) of the Constitution. This article talks about holding office, what should bar you from holding the office of a member of Parliament and other sensitive offices, specifically talking about owing allegiance to Ghana and other countries. The question remains whether at the point that Mr. James Gyakye Quayson picked up his nomination forms to contest for the seat of Assin North on the ticket of the NDC, whether he was or he owed allegiance to any other country besides Ghana, and that is the matter that is pending before the court. So this injunction was only to, in the meantime, put James Gyakye Quayson out of office, just to ensure that as the Attorney General and the lawyers for Michael Ankwama Nimfa put it, to ensure that there is no constitutional aberration, that the people of Assin North are not taken for granted.
Now, I mean, the ruling was 5-2 majority. I believe. How different is this ruling from other, rulings related to this particular case?
Well, we have seen in instances where decisions have been taken unanimously. In this particular case, we have seen a majority decision. What that simply means is that 2 of the 7-member panel did not agree that James Gyakye Quayson should be barred from representing the people of Assin North whilst the matter is heard.
Now, does this bring finality to the call for him to be restrained, or is there room for appeal? If you can educate us.
This is an equitable remedy. As it stands now, like we said, it is only in the interim, and this is a discretionary remedy. In other words, the court had a discretion. This is a ruling that the court gives out of its magnanimity and its own reasoning. It is not the end of the matter, for what it's worth. It's not the end of the matter. It's not the finality to the matter. It is possible that after all of this, we would see James Gyakye Quayson back in office as the Member of Parliament. But of course, as we have seen the plaintiff applicant in this matter, who is Michael Ankwama Nimfa, his lawyers hint at every turn, there is the advocacy or the push for the Electoral Commission to strictly work with the judgment of the High Court, by which judgment it would mean that the EC would have to immediately move into Assin North and conduct a by-election.
Now, what do the residents themselves make of such a ruling? Our correspondent for the Central Region, Georgina Apia, has hit the ground to interact with some members of his constituency to get their reactions.
Assin North in the Central Region is a young constituency created in the year 2012. Since the creation of the constituency, both the NDC and NPP have held 1 full term each. Gyakye Quayson was to be the NDC's second in the constituency. In 2012, the NDC's Samuel Amber won the seats, and in 2016, the NPP's Abna Drowa Mensah snatched it with about 500 votes. 2020 saw James Gyakye Quayson of the NDC win the seat with close to 3,000 votes, as he polled 17,498 against his closest contender, Abna Drowa Mensah, who had 14,793. According to constituents, the legal tussle has affected development in the area, especially in the area of road construction and job creation. They, however, received the Supreme Court's ruling with mixed reaction.
Yes, I hear any ma Obian Kahin, I'm Puntujima, Moya, Henino. I say, I'm boys on Bay Juma and my own Bay Juma, Pierre Jumanye. I'm a grower, quiny, toilets in the idea. Be dear any groom. We a BSP. So Bekai Abusa Candia is see Woma Bresso. Trina Manuka Mumpo. And this is a way when you are feeling Emrano, because I lawyer for Yan or Motua, I judge for Yan or Motua, or Mubia, Aba, Mribia, Toya, a Koya Pinchi, and Pipi, the Copier Court, or Mukuya, Netana, as someone so Mubia, and the Neye, Sisi answer Uncle Vokuya Ansuna, or Motua, or Mubinti Emradie, a Emra, as I say, Yadia Juma.
Honorable, more might be beer Munabem, and the Omokano. Yadi Yatanachi, a womo, and Quamo, Yatanachi, Yabesi Yatanachi. Say, what was someone Panosa, no Sabon Podian and your double. You bet soon a double, no Macas or Mahu. No question, or no one, your panel.
Both NPP and NDC party executives also reacted.
We are not afraid of them, and we know say it will go in favor of us. Because when conforming GDA, everyone we are praising man, almost to about Edemano. And it's an Assin North for say, ye pay you are crazy. It is a general mosquito, Ekaeno. We are not run away from any re-election. And if we go for the re-election, it will go in favor of us.
Yeah, MPP for there. Yeah, Jim ready. Anna, you mean the Embraso Eden. Ewo Omaimu. Yemfa and Tokwa and Ase Bibi, sir. Bibi Enia or say a treeable. Now the Kodai court to no. Your court to no Becano. And no an Eden, MPP for Eden, ye do so. Now, when you say, said ye, Adiana Ayeno. Ye need a quite say, there will be a possible by-election in Assin North. Right now, the seat is vacant.
Reporting from Assin Breku in the Assin North constituency of the Central Region, my name is Georgina Apia for City News.
Now, this parliament is like no other. And prior to the ruling of the Supreme Court, we had the majority group consisting of 138 MPs. The minority on the other side, with James Gyakye Quayson, as part of them, stood at 137. Now, the closeness of the numbers has more or less affected the way Parliament has conducted itself in this particular session. It is currently in recess, but I have my colleague in Parliament, Duke Meso Puku. The implications of this ruling will be.
The reality may not hit home right away because, as is evidenced by my surroundings, Parliament is eerily quiet. Surroundings are almost deserted, essentially because the House is on recess and is on break for the Easter festivities and will be back later in the month of May after a 5-week break. So the reality of the Assin North Member of Parliament not being able to hold himself out as a Member of Parliament as instructed by the Supreme Court may not hit home right away. Its implications, however, will kick in when Parliament resumes from recess later next month, that is in May. In which ways will this judgment affect proceedings? Number one, effectively, the minorities numbers for all operational purposes, for all intents and purposes, is reduced to 136. This means that if there's any crucial vote and it comes to voting, if the majority is able to marshal all of its numbers, it will vote 138 and the minority can only vote 136. That is the first thing. Secondly, it will also affect the committee system or the committee work that goes on in Parliament. It looks like the minority were anticipating this outcome because on the day when the e-levy was passed, even though he was in Parliament, having attended 2 court sittings, the Supreme Court and then the High Court where his criminal matters just began, he was not allowed to come into the chamber. Even when they even wanted to walk out after the e-levy was passed, he was not allowed. And they indicated that because of the possible ramifications it may have by way of what the Supreme Court will say. So I must say that in that light, the minority were in a way expecting this judgment from the Supreme Court.
From the Supreme Court of Ghana, my name is Bobie Ose. Let's now cross over to my colleague Zoe Abubedi for some more stories.